Hello, my name is Jonathan Culbertson, and I am the Compliance Manager at InCheck. Today, I will be bringing you the April 2022 Compliance Update. The updates I will be discussing affect background screening, as well as the hiring process generally. To kick things off, I'd like to mention a couple significant compliance updates regarding Form I-9s. The U.S. Department of Homeland Security, or DHS, previously announced a temporary flexibility that allowed employers to use expired List B identity documents when completing the Form I-9. Recently, however, the DHS announced that this flexibility is set to expire on May 1st, 2022. Employers that accepted expired List B documents between May 1st, 2020 and April 30th, 2022 must update their Form I-9s by July 31st, 2022. If the employee is still employed and the expired List B document was not extended. Now, there's another Form I-9 flexibility that you're probably aware of that allows employers to virtually inspect identity and employment eligibility documentation until the employee undertakes non-remote employment on a regular basis. The U.S. Immigration and Customs Enforcement has extended this flexibility until October 31st, 2022. Now, let's pivot to a few compliance updates regarding pay equity laws. Washington amended the Washington Equal Pay and Opportunities Act to require employers to disclose in each job posting the wage scale or salary range and a general description of all the benefits and other compensation to be offered to the applicant. The legislation takes effect on January 1st, 2023. Locally, New York City amended the New York City Human Rights Law to require employers to include a minimum and maximum salary for the position in their job advertisement. As of now, that law is scheduled to take effect on May 15th, 2022, so just around the corner. New Jersey City passed a similar ordinance that requires employers to include in any employment posting a minimum and maximum salary or hourly wage and benefits. Okay, let's transition over to some information regarding marijuana laws. At the federal level, the U.S. House of Representatives passed the Federal Marijuana Opportunity Reinvestment and Expungement Act, or MORE. Although MORE Act has been passed by the House, the MORE Act would still need to be passed by the U.S. Senate to be enacted. If enacted, the MORE Act would decriminalize cannabis at the federal level by removing cannabis from the Federal Controlled Substances Act. At the state level, we also have some news as Mississippi passed the Mississippi Medical Cannabis Act, or MMCA. The MMCA legalized medical cannabis for individuals with a debilitating medical condition. It is of note that the MMCA is employer-friendly and does not contain employment protections for medical cannabis users. In fact, the MMCA states that it should not be construed to prohibit an employer from taking an adverse employment action against an individual as the result of the individual's medical use of cannabis. All right, so there's two more updates that were in the news that I would like to share with you today. The first comes out of Wisconsin. As you may know, the Wisconsin Fair Employment Act, or WFEA, states that it's employment discrimination if an employer refuses to employ any individual because of their arrest record or conviction record. However, the WFEA states that it's not employment discrimination to refuse to employ an individual if the circumstances of a pending arrest record or conviction record substantially relate to the circumstances of a particular job. Traditionally, the Labor and Industry Review Commission, or LIRC, has repeatedly held that domestic violence convictions were not substantially related to various prospective positions because the probability of recidivism of a crime of a domestic nature was not likely in an employment setting. However, again, the Wisconsin Supreme Court in Cree versus LIRC recently clarified the substantially related test as it relates to applicants with a domestic-related criminal record. The court stated that an employer may lawfully not hire an applicant because of a domestic-related criminal record if the employer can show that the facts, events, and conditions surrounding the convicted offense materially relate to the facts, events, and conditions surrounding the job. The domestic context of such offenses is immaterial to that test. And last, New York City passed a law that prohibits employers from using an automated employment decision tool to screen a candidate or employee for an employment decision unless the tool has been the subject of a bias audit. The summary of the results of the bias audit must also be made publicly available on the website of the employer prior to the use of the tool. Additionally, the law requires, among other things, that the employer notify each employee within 10 business days before use that an automated employment decision tool will be used in connection with the evaluation of such employee or candidate. That law takes effect January 1st, 2023. Well, that wraps up the compliance updates for April 2022. I'd like to thank you for listening, and I hope to see you again next time for some more compliance updates. Thank you. Have a good day.